We've got a programme which is very, very full tonight, so it'll sound as if we're rather having to hurry these things on. Don't worry, we hope to get it all in and have a complete scamper through international criminal justice tonight. I'm very pleased indeed to introduce Geoffrey Robertson, founder and co-head of Doughty Street Chambers. And who better to introduce our International Criminal Justice series?
Thank you so much, Elizabeth. It's a great honour and pleasure for Doughty Street to be involved with Chatham House in this first of what we hope will be a series of seminars on international criminal justice. Milestones in it. I was at the Ford Foundation's celebration yesterday for its 75th anniversary, and I thought back. I didn't think back, I looked back 75 years. 75 years ago, the world was reading in amazement of the purge trials in Moscow, Stalin's attempt to rewrite history by eliminating those who made it, and many million more besides. There was no CNN, no WikiLeaks, no Twitter, no international justice organizations observing. Human rights was not a word in the lexicon. It became a word 3 years later when a little group of English lawyers and writers, led by H.G. Wells and Viscount Sankey, the first Labour Lord Chancellor, devised the first of the modern human rights conventions. J.B. Priestley, Barbara Wootton was on the team. A.A. Milne motored up from Pooh Corner to add his bit to the draft. It eschewed all the messianic declarations of the American and French revolutions, and it began quite simply by basing human rights not on the law of nature or the grace of God, but because a man comes into this world through no fault of his own. It began, he is in justice entitled to rights that would be enforceable even against leaders. H.G. Wells and the Rights of Man became a bestseller. It sold throughout the world. The British Foreign Office had it translated into German and dropped by Spitfires on the Nazi tanks as they swept across France. They didn't stop to read it, but President Roosevelt did. He was a friend of Wells, and it inspired his famous Four Freedoms speech, fighting for a world where freedom of speech, freedom of worship, freedom from want, we haven't done much about that third freedom, but that's another seminar, and freedom from fear. And where we're talking about today is the progress we've made in freedom from fear. Of course, after the war, there was the dispute over whether Nuremberg should even happen. Churchill was afraid that it would give ventilation to Nazi theories. He wanted the top Nazis, 75 of them, he drew up a list, to be given 6 hours to say their prayers after their arrest and then be shot. It was owing to Truman and to his advisor Jackson that we did get the vote for Nuremberg, but it was deadlocked between Britain and the United States whether we should have the Nuremberg trials at all. And that deadlock was broken, of course, by Joe Stalin, who thought everyone should go on trial so long as they were shot in the end. And so by that unhappy, perhaps, alliance, we got the Nuremberg trials. And of course, those trials, fairish only as we would see them now, did end the prospect of Holocaust denial. It is funny to look back on them in a way, because they succeeded because, first of all, the Nazi defendants played along. When the trials, when they were first put in prison, Goering put them all together and said, no, look, we're going to say 3 words to these judges. One catch cry, one of Goethe's warrior heroes, loosely translated as kiss my ass. But as the trial preparation got underway and they realized that they would get a fair trial or a fairish trial, they decided to cooperate, and there was none of this nonsense we get now from defendants screaming from the dock of the witness box. In fact, if you watch that old newsreel of Goering coming up with his speech and being told by Geoffrey Lane, this is not the time for speeches, plead either guilty or not guilty. And then they dropped his notes, and the collapse of the Stout Party as he went back. That was one reason why it succeeded. It also succeeded because, of course, as Jackson, the prosecutor, said, and I quote, because of the Teutonic habit of writing everything down. They had Goering's signatures on the night and fog decrees. They didn't have the problem that many courts now have, certainly in places like Sierra Leone, of working from informers only, of having no documentation, or, as in the case of Serbia, having governments that refuse to allow documentation. Well, the Nuremberg, of course, was the great milestone in creating international criminal justice. After Nuremberg, we had the great human rights triptych, the Universal Declaration of Human Rights, the Geneva Conventions, and the Genocide Convention. They were followed over the next 50 years by all sorts of good conventions, conventions against racism, conventions against torture, against the maltreatment of women and children. The good conventions, someone said, surveying the killing field in Rwanda, the road to hell is paved with good conventions. Yet really no enforcement mechanism attached. And even when the tribunals, the ICTY and R, were set up in the 1990s, they began as fig leaves to cover the UN's failure to do anything about the killings. But of course, with the Pinochet case, and the Pinochet precedent was enormously important, coming as it did at the end of the millennium, we had, for the first time, the suggestion that there might be a law against tyranny, that there might be an international justice that could actually bring heads of state to trial. And when we think back only 10 years ago, it hasn't been very long, 11 years ago, all those debates, Norman Lamont now holding I think the medal of Pinochet second class, was led an international lobbying for Pinochet. It began, of course, former George Bush, Dr. Kissinger, the Pope in waiting, all those heads of state, including, bizarrely enough, Fidel Castro, who petitioned Jack Storr and said this was keeping Pinochet under house arrest, or even though it was manor house arrest, was in effect an insult to the heads of Latin American states. Well, cutting a long story short, we now have in a very short time, and I stress a very short time because there are a lot of criticisms of international justice, of the length of time, and Milosevic case was a disaster in that respect, of the cost, of the overzealous prosecutors who keep putting everything, including stealing the bishop's horse, as Bernard Shaw said in St. Joan, into the indictments. And they take all those criticisms aside. In a period of just 10 years, we've come from the quizzical hostility to what's the arrest of Pinochet going to do to democracy in Chile? All that to the general acceptance, I think, with the Karadzic trial and now with the arrest of Mladic, that international criminal justice is a good thing. We've got Charles Taylor, albeit that trial might have put on the map by Naomi Campbell. That verdict is coming in 2 weeks' time. We have that, another head of state to look forward to. And I think the great milestone, although it hasn't at this point been recognized as such, was Resolution 1970 of the Security Council, which, unlike the Darfur resolution some years ago, Resolution 1970 was unanimous. It was a unanimous referral by the Security Council of the situation in Libya to the ICC. So gone is the time, and it was only a few years ago, it was 1994, when American hostility was so strong and so puerile that they passed the American Servicemen's Act, the so-called Bomb the Hague bill, which empowered President Bush to bomb The Hague, to attack Holland if any American were ever to be arrested by the International Criminal Court. So we have come a long way. We've come and we've created, and this is the worrying thing perhaps that should weigh heavily on the international conscience, we have created expectations. In the streets of Syria today, enormously brave young people are holding up a banner. It reads, Al-Assad to the Hague. That is the extent of the expectations that international justice has aroused in people who suffer oppression and who suffer from tyranny. The world now has a duty to deliver on those expectations, expectations that were doused, of course, by the killing of so many in Iran, by epitomized, I suppose, in the picture of Neda. But we have aroused these expectations, and the way forward surely is not the squalid little exercise that happened with Saddam Hussein when the demands of international justice were rejected by the United States. I was one of the people who trained Saddam's judges, and it was quite clear that the Americans were determined, although the British put up a bit of a fight, were determined to have him avoid international justice for the simple reason that they wanted him killed, they wanted him executed, they wanted the death sentence, and international tribunals don't impose that. I did suggest at one point that, because they said, you know, we can't have him in Iraq, that was fine, we can't have him. We said, what about he'll go to Finland or somewhere for the rest of his life? Oh, but he'll have 140 channels of television, most of them showing pornography. You can't put him in Finland, that's not a punishment. So we then, the British suggested, well, perhaps we could do what we did with Napoleon and put him on St. Helena. And the British Foreign Office actually inquired of the St. Helena's council whether they'd cope with him, and they said, well, we're trying to develop a tourist industry down here. So that was off the possibility. It would have been nice if they'd put him in the Falklands, I suppose, where he could commune with penguins and never be heard from again. But they are the sort of problems that international justice has faced. But we're underway. The milestones are being passed. There's a long way to go. And the speakers who follow me, I'm sure, will tell you of them. But it's worth remembering, for all the criticisms, that we have come a long way in delivering on the Nuremberg legacy in a very short period of time.
We're going to pass straight on to Judge Howard Morrison, judge at the International Criminal Tribunal for Yugoslavia.
Thank you very much, Elizabeth. International law, as Geoffrey says, has come a long way. I believe it's crossed the line in international public perception between obscurity and acceptance, albeit an acceptance which is tinged and still riddled with some confusion. It's getting better. Back in 2006, I was driving home from Birmingham Crown Court, and I listened to the radio, and there was a talk program about the trial of Saddam Hussein, and it was an indignant Hungarian professor of law, as he described himself, saying that Saddam Hussein should have been tried in the International Court of Justice, but wasn't because the Americans didn't recognize that court. Well, it would have interested the judges at the ICJ to discover they had a newfound criminal jurisdiction, and I only hope his students got their money back. But there we are. It hasn't altogether changed. I was reading a blog attached to an article in the Daily Telegraph. Settle down, I read The Guardian as well, where it said that Mladic was off to be tried at the ICC. Well, it's a small mistake in some ways, but a very important mistake in others. Of course, Mladic is being tried at the Yugoslav Tribunal, and it would be nice if people who write such articles in widely distributed newspapers did know the difference between the ICTY and the ICC. If they don't know the difference, it's very difficult for the public to come to know the difference. But that's a minor issue. The real problem I see in the state of international criminal law today, particularly when we look at the ICC, is we don't have enough people in the club. I was at the prep comms for the ICC, the Rome Statute, back in 2000, and the United States took a front-running role in those preparatory commissions. Indeed, it's where I first met Elizabeth Wilmshurst. So it came as a very sad realization to me that they weren't actually going to join up. And of course, it's not only the United States, which is the big player who isn't there, nor is Russia, nor is China, nor is India, nor are many states in the Middle East who ought to be. And the reason I suspect that they're not is the old arguments about not wanting to see their sovereignty diminished in one way or another, and a straightforward fear that some of their citizens might end up being indicted by the ICC. Well, understandable though that is, it is no good reason, in my judgment, not to sign up. I can't go any further than that. Judges don't make political comments. Anything I say which sounds vaguely political, put down to the acoustics, because I don't do that sort of thing. But that's a problem. It's got to get better. We've got to get more people in the club for it to be truly international criminal law and truly the International Criminal Court in due course. There are still the old fights going on between those that come from a civil law background and those that come from a common law background. Do we have a normalistic approach to international criminal law? Do we have a pluralistic approach? Do we have everything written down and codified, and strong German academic views as to that, and equally strong academic views from some people in the common law that we should let it evolve on a more case-by-case basis in the way that precedent in common law has evolved? There are valid arguments for both sides. One of the best arguments for a normative, a written set of rules everybody understands, is that you know what you're going to do when you get there. That is not simply a sideline, it's very important. I started off in international criminal law by filling in an advert in Counsel magazine in the UK. It said, do you want to defend at the ICTY? And I looked up the ICTY and I thought, that's not a bad idea, and I filled in the form, sent it off and forgot about it. And about 2 months later I got a phone call in very bad German, which I responded to in my equally bad German, and I discovered that it was a Croatian defendant in the detention centre in The Hague who wanted me to represent him. And so I did. That's how I got involved. And it was the Celebici appeal case, which was quite a seminal case because it was the first command/superior responsibility case since Nuremberg, so it was very interesting. But when I got to The Hague, I wanted to do things the way I'd done them in the UK. The Americans wanted to do things the way they'd done them in America, and so on and so forth. And it wasn't until this alphabet soup got mixed up quite considerably, and that took several years, that we began to feel that we had a more homogenized system of law. It's got a lot better since. There's a lot more jurisprudence. There's a lot more learned involvement. There's some great books about, and that helps everybody a great deal. But in spite of all that, we still have this division between common law and civil law, which I think is unhelpful. I think it's better that we take the best parts of both systems and apply them all. Perhaps that will come. What we have done, fortunately, is seen the incorporation of the defence into the organic structures of the courts. That didn't happen in the early days. When I first went to the ICTY as defence counsel, when you walked past somebody with your defence counsel badge on, they made the sign of the cross. And it wasn't that easy. You couldn't even go in the library as defence counsel without somebody from the staff accompanying you. I don't know whether they thought we were going to discover a defence or steal the books, but either way, you very much felt like a second-class citizen. That's been wholly resolved, and a very good thing too. And it's, of course, the defence is part of the organic structure at the ICC, the Special Tribunal for Lebanon, and I think virtually every criminal tribunal and court now. So there have been huge advantages. We are beginning to understand the things that we concentrated on in the past may not have been the right things. There's been too much selectivity in certain places, and that there needs to be a broader brush painted in terms of selection of cases. That's easy to say, it's difficult to do. Why is it difficult to do? Because apart from anything else, it's jolly expensive. And the international community doesn't have an unlimited budget or an unlimited purse. So to that extent, at least there has to be some selectivity. There is a criticism amongst some African states that the ICC has concentrated too much on African cases. Well, I can see the perception, but if you look at it from the other end of the telescope, you can say, well, actually, the reason why it's being done is for the protection of those people in Africa against whom it is alleged that there are egregious offences being committed. So, in fact, it should be applauded rather than denigrated. But there's two ways of looking at the same problem. The understanding now, through the development of the jurisprudence, of the awfulness of rape as a war crime, of the fact that it's women and children who often suffer the most in these dreadful international crimes which are committed, genocide, crimes against humanity, aspects of war crimes. It's now beginning to be understood that that is really the thrust of the matter. I spent 4 years defending at the ICTR. I heard the most gruesome things about the Rwanda genocide, and it struck me that although one doesn't in any way diminish what happened to the male who were butchered, the females and the children, who are more helpless perhaps, suffered the most and in the most terrible way. And it's for those people that international criminal law must strengthen and must go forward. We all are in a pretty safe environment by and large. There are many, many people in the world who are not, even now. Let's not kid ourselves that we've ended impunity. We are along the road to ending impunity. We are along the road to ending immunity. It's all very well for a statute to say that there is no immunity, but as long as a nation doesn't do something to further peace and reconciliation with neighbour states, and as long as the international community doesn't do it, then impunity is going to stay, and there might just as well be immunity. So that's got to be worked at. We're going along the road. We can't claim an abundance of success, but we can claim to be going pretty firmly, and as Geoffrey said, pretty rapidly in the right direction. The role of victims coming into the picture. At the ICC, for the first time, a particular focus on witness participation in trials. How that is going to work out in practice has really still got to be ascertained. You can't have 2,000 victims all being represented in one case. The trials would take decades, the costs would be astronomical. So somehow you have to fit in the concept of witness participation with the realpolitik of what you can actually do. But the ICC is at least working towards that, and I think there are some very good ideas in the pot. And to the ICC, well, the ad hoc tribunals, ICTY and ICTR, are coming to the end of their mandates, although with the arrest of Mladic and Hazic, there's going to be a few years left yet. But at the end of the day, the successor court is going to be the ICC. What matters very much is that the ICC is seen for what it is. It's a senior criminal court, and it needs to be staffed by people who are criminal practitioners, criminal judges who know how to administer a criminal court. It deals with human rights, but it is not a human rights institute. It is not a PhD factory, and it's not an employment agency. And those ideas need to be firmly hammered home. And when it's seen to be going forward as a senior criminal court, doing an efficient, which means an expeditious and cost-effective job, then hopefully that will come full circle and lead more people to join the club. And if there's anyone here who has any influence with their governments, if it's a government which is not a member of the ICC, do your best. It's really important. I did a case, or part of a case I did in Arusha was this. It was an 8-year-old girl who was with her mother, her brother, and her father walking down a road when they came across a roadblock. They had fake identity cards. They were all Tutsis, but they had fake identity cards. It didn't wash, and the Interahamwe, who were manning the roadblock, realised they had a family of Tutsis with them. They tied the father to a tree and they emasculated him in front of his wife and children. They then raped the wife and cut her throat. They sexually assaulted the boy and emasculated him. They then repeatedly raped the 8-year-old girl, who was the only one who survived, and she survived because she was lucky enough to be left alive after this drunken orgy of violence and sex, and was picked up by someone who took pity on her and took her home. Her name was Alice. We're here for Alice. Thank you.
Now we're passing to the ICC, and we have Rod Rastan from the ICC Prosecutor's Office and Elham Saudi from Lawyers for Justice in Libya, who are both going to talk generally about the ICC and the Libyan arrest warrants.
Well, thank you very much to Chatham House for the invitation, and the two of us have 10 minutes each, so we'll try to respect that as much as possible, and then have lots of time for questions, I'm sure. I'll try to speak generally about the work of the court, and then we can probably come to Gaddafi towards the end of that in terms of some of the challenges that demonstrates. The ICC, as we've heard, really builds on the milestones achieved by the ad hoc tribunals that succeeded Nuremberg in some ways, and the project is now 10 years old. The ICC statute was negotiated in 1998. The court came to be in 2002, so this coming year will mark the 10th anniversary of the existence of the court. The fact that it's even in creation was seen as a milestone by many. The fact that so quickly, so rapidly, within 4 years, the 60 states necessary ratified the statute. Many states see it to pass implementing legislation to be able to actually comply with some of those obligations, or to be able to themselves constitute national trials. But nonetheless, the achievement of having that number of states ratify the statute to enable it to come into being was seen as a milestone in and of itself. And then within such a short period of time to have a number of cases either referred to the court, or in and of itself, Darfur was significant, to have the Security Council turn to the court after there was a lot of ambivalence, as you will recall, and lots of suggestions of alternative forums to have the Darfur issue dealt with, either by extending the mandate of the ICTR, creating a special court for Darfur. And in the end, everybody really pointed to the fact that the ICC was established for this very purpose. It just didn't make sense to set up another court for this. So despite some abstentions, notably by the US and others, that was in itself a significant milestone. And then passing obviously to the fact that now, as of this year, to have a unanimous resolution where countries such as the US, China and Russia are positively voting in favor of a resolution, obviously, makes the ICC now part of the furniture of the international community's arsenal of tools, if you like, to deal with international crises. Justice is no longer seen as an exception. It's now increasingly being seen as the norm, as part of the standard responses expected. So the questions are now being raised in terms of the Security Council's treatment of different crises. Why not other situations? Why not, let's say, Syria? Why not Sri Lanka or other situations? So what the court faces now is that it's become increasingly normalized. It is now routine to expect action. So the question now devolves around that which we've just heard, about the universality of the court, which continues to be the major challenge of the ICC. It is an international criminal court, but it's not yet truly universal. Obviously, its state party membership is growing. We have 117, possibly 118 now. States have joined. But still, some significant gaps remain, particularly in the Middle East and in Asia, as well as some of the major powers. So that is an issue which obviously will have to resolve itself over time, and we're seeing in the Middle East renewed interest, Tunisia joining, Egypt expressing interest in joining, and others. And increasingly, those countries in the region which used to be afraid of the court being used as a tool against them, or that the court would investigate abuses by interior ministry in terms of routine human rights abuses, now increasingly seeing the court is a form of protection for their own citizens, particularly in the wake of the Arab Spring. So the Middle East, a renewed interest in the work of the court. The Palestinian National Authority also coming to the court and lodging a declaration requesting the court to investigate events there. An issue which is obviously very much linked to notions of whether or not they have the capacity to lodge such a declaration, and it's linked to some extent with the discussions going on as we speak in the General Assembly. All of these sort of attempts to turn to international jurisdiction are showing a renewed sense of the relevance of the court. And even in Asia, we have a sense that countries are turning to membership. Malaysia and Indonesia are in the process of passing relevant legislation. Philippines just joined. So there is a sense that the court's role is being established. However, nonetheless, of course, there will be many situations where the court simply won't have jurisdiction because the relevant acts do not occur on the territory of a state party or by the national of a state party. And in those situations, the decision then falls to the Security Council because, as you know, the Security Council has the authority to refer any situation to the ICC pursuant to its own Chapter 7 powers. So, as I say, increasingly the question is not so much about where the court itself exercises jurisdiction and where it opens investigations, although that will remain, but also in terms of the role of the Security Council within this apparatus. So in terms of the work of the court itself, what has been achieved in the last 10 years? Well, the court has a number of investigations obviously open. As of date, 6 investigations are open, all in Africa, dealing with situations such as Uganda, Congo, Central African Republic, Kenya, Libya, and now Côte d'Ivoire is opening up, and of course Darfur in Sudan. A number of other situations around the world are under, if you like, the radar of the court, where we're considering opening investigations. Some say that we should have opened investigations by now. Others saying that the court's role is to prod the national authorities to do the cases themselves under the notion of the complementary need for national action. And those are situations such as Colombia, Afghanistan, Georgia, amongst others. Interestingly, situations such as Georgia, a non-state party, the Russian authorities, have come to the court urging us to investigate because they believe the crimes were committed against their peacekeepers. At the same time, the Georgian authorities are also turning to us to ask us to investigate. So we are assessing national proceedings. But it's interesting that the Russian authorities have actively requested the court's involvement in relation to that situation. And then the cases that have come out of these situations, they are limited in number because the court's work as a permanent institution has to be seen probably differently to the work of the ad hoc tribunals, which were engaged for 10, 15 years in one situation, which had the ability to bring, in the case of the ICTY, something like 160 indictments over 15 years, 100 or so in the case of the Rwanda tribunal. I think nobody has the expectation that the ICC will be able to do 100 indictments in each of the 6 investigations already currently open. It's simply not feasible. But the question is, how many can it do? The Special Court for Sierra Leone, around 12, let's say, with representing 4 of the main factions involved. Perhaps the ICC should aim something around that number, but there will always be a cutoff point. So the question of selectivity also comes in terms of selection of cases and prioritization of cases and how that's done. And those decisions will generate intense debate. When you have a court issuing 100 indictments, there'll be a lot of scrutiny over the 100 that are chosen compared to the thousands involved. You can imagine how much more intense that scrutiny is when the number is 6 in the case of Kenya, 3 from the 3 each from the associated with the 2 main ruling parties in the coalition government. In the Congo so far, we've had warlords from 3 of the main armed groups, resulting in 5 indictments. In Darfur, we have 3 related to the government side and 3 related to the rebel side. Of course, these are still works in progress. Libya, we have 3 indictments, and more will follow in relation to both the government and the former rebel side. So that discussion will continue to generate debate. People will consider that either we made the right choices or perhaps the wrong choices. But the policy that drives that is something that we've looked into the experience of the ad hoc tribunals, is really that it makes most sense to focus our investigative efforts on persons who appear to bear the greatest responsibility for the commission of those crimes. Not the foot soldiers, perhaps not even the commanders, but people who may actually have no blood in their hands whatsoever, who may be several steps removed, either in a civilian capacity or at the top military capacity. But for that very same reason, those cases will be the most complex and difficult ones to prove in court. So you also, if in some ways, you take a risk with those cases because they are very difficult to prove, as you know. There's very rarely, you get the case where there are direct orders saying, from the top leaders, saying that the civilians should be massacred. And actually the Libya case is quite the interesting one in that respect. Whereas normally we have lots of evidence relating to the crime base and have to build up the linkages towards the persons at the top. In the Libya case, from the outset, it was the reverse. You had very open public admissions by Gaddafi, by Saif al-Islam and others, saying that they will go house to house, door to door, and massacre anybody who's left, who's associated with the demonstrations. But very little information about the actual crime base. A lot of confusion about actually what was happening on the ground. But that was also one of the reasons why we were able to move so quickly. Once we were able to establish the crime base, the linkage evidence was followed. So maybe, I think I'm running out of time. Just to wrap up, what are some of the challenges that remain? Obviously, we don't have time to go into some of the cases, but I think the complexity of the proceedings, indeed, even more complex than at the ad hoc tribunals because of the two-stage procedure where you have a confirmation of proceedings to filter out the cases that should go to trial, but that adds to the complexity, as well as victims' participation, which adds another layer of complexity that the court has to deal with. It's one of the innovations of the Rome Statute, but it has to be done in a way that leads to the efficiency of the proceedings. The cases themselves are highly complex because of the nature of them, because of the persons implicated at these highest levels. And then I think a number of four themes perhaps stand out more generally in relation to the work of the court as a whole, thought of as the system to bring international criminal justice into being. And this is the notion of a system of a court interacting with national courts, a criminal justice system in that true sense. And just to cite those off in 4 bullet points, the issue of cooperation, which is perennially the Achilles heel of all courts and tribunals, to get arrests as well as gathering evidence, where they have to rely on national authorities. The issue of complementarity, how to get national courts and the ICC to complement each other's activity, so that those few cases at the highest level at the ICC are complemented by the bulk of cases at the national level. Even today, after 160 indictments at the ICTY, thousands of cases are before the state court in Sarajevo, the war crimes chamber, and in Belgrade and Zagreb. The bulk will always remain at the national level. How to implement that, particularly when those states have been found to be unwilling or unable themselves at the initial stage to investigate or prosecute. How to deal with the peace and justice dilemmas, where now increasingly the mantra is you need peace and justice, but how does that work in practice? And then finally, the role of victims. How to include victims in terms of the proceedings themselves, how the outreach activities work, and how the process becomes meaningful for them. So at that, maybe I can hand over. Thank you.
Thank you very much. I think I will start by repeating one of the chants that were going around Tripoli on the 20th of August when the city was liberated. I'll say it in Arabic because it rhymes and then I'll translate it. So it goes, Ya Gaddafi bye bye, wahed tis'a fi lahai, which means Gaddafi bye bye, on the 1st of September you'll be in The Hague. The 1st of September is obviously crucial because it would have been the anniversary of the 42nd year of his revolution. I think that summarizes a lot of the points I want to get to. What I want to talk about is 2 areas really: the perception of the ICC Libyan case on the ground, and then some of the shortcomings that have come out of people's reactions and the reality of the case. I think the first thing I'll highlight is, again, the point that was highlighted before about Resolution 1970 and how quick and how forceful and how impactful it was. It was 11 days after the first peaceful protest, and it was a unanimous decision, and it was a very big boost to the opposition on the ground that the international community was behind it. And I think that's something that leads me later to one of the main points, which is the role of the ICC as actually a symbol of hope for a lot of people on the ground, and its need to own that role more than it does. So the first perceptions we had on the ground in Libya through our work is just the sheer glee at the prospect that Gaddafi would be arrested, that Gaddafi would face justice, that Gaddafi would face the justice that he deserved, and that the victims would get the justice that they deserved as well, a fair trial, a proper trial. As time progressed, those perceptions were enhanced by some of the statements of the prosecutor, by some of the facts that were coming out of a very quick-moving process. The indictments indeed came very quickly, the 3 indictments for Gaddafi, Saif, and Senussi. And it felt like there was a real sense of movement, that there was definitely going to be an end to impunity in our case, and an end to immunity for Gaddafi and his family. But I think that's when some of the positive vibes sort of started to halt, because after that there was very little and very sparse in between in terms of communication between the court and the people on the ground who were seeking the justice. And I think there was a sense that there was everyone in Libya. The press was there, many of the NGOs were there. There was people there collecting evidence of their own volition, but there was no sight of the ICC, and they were always coming to us for explanations on that. There was no explanation as to what the function of the ICC was, what the processes were going to be, what happens after these indictments. It just felt like it was starting to become a very distant prospect, and one that was perhaps halted to some degree because of the lack of communication. And these sort of conversations we kept having over and over again with people saying, well, why aren't the ICC here, the BBC's here? Why aren't the ICC here, the Jazeera's inside collecting this evidence and showing it on TV? We have all these statements we want to share. And so that got us thinking, and we actually as an organization have about 70 lawyers on the ground in Tripoli and elsewhere collecting evidence that we do share with whoever wants to see it, including the ICC and the African Court. But I think it was the sense of misunderstanding of the great words on television and then the action on the ground. And I think this led me to think of 6 areas where I think are perhaps practical shortcomings. I'm a huge fan of the ICC, so this is by no means a criticism. It comes from a place of love. It might be a form of tough love, but it definitely comes from a place of love. I think so these 6 areas, I think the first of which is the management of expectations, which Rod alluded to. There was just the sort of difference between the massive reaction to Libya and the momentum and then the halt. Is not actually only in the Libya case. If you look at statistics in the Kenyan case, in December last year, 78% of a population poll were in support of the investigations, and that's dropped to 51 now. And the reasons that the pollsters have given were fatigue and lack of additional perpetrators being brought to trial, and the lack of knowledge of what was happening in the process. And I think those are the same things we're hearing echoed in Libya now. Okay, so it's a much shorter time frame. It's only been a few months, but it's this concept that there is perpetrators that everyone is aware of and that haven't been added to the list. The one that's been brought up the most recently is Saadi Gaddafi, who's in Niger, which is a signatory to the ICC. And is there and sitting there in his villa, and there doesn't seem to be any proclamations of anything coming in that direction. The second area is accessibility. And I think it's there's a lot of focus on the investigations, and a lot of focus when the court talks about investigations about the need to limit numbers. It's very expensive. It's very difficult. It takes forever. It takes a really long time. And all those are very valid reasons, and they're reasons that we all, obviously, as lawyers know and know the process. But that doesn't get communicated in a tangible way to the people on the ground. And so there's a real sense of 3 people are going down for this, that's it. You know, there's tens of thousands of people dying. There's tens of thousands of people being tortured. And I think there needs to be a communication there explaining the rationale for the limitation of numbers. But actually, I think there's also more that can be done. The foundations on which the court was built was that it was to give a voice to victims. And I think that's one of the hurdles that it's perhaps tripping on in terms of procedure and bureaucracy. So I think there is something to be said for giving victims a voice, even if they don't end up voicing it at The Hague. But one of the examples I have, I think Crime Stoppers, or whatever, Crime Watch in the UK gets 100,000 calls a year that are all actionable. They take a few of those, but there is a cathartic element in telling your story. And I think one of the things I did just before on my way here was look on the ICC's website to try and find a link if I wanted to share something, or if I wanted to give information, and it was pretty difficult to find a contact to do that. I think how am I doing for time?
You're okay.
Okay, good.
We're interested.
Good. The third area is responsiveness. I think one of the crucial elements of a prosecution or an investigation is its ability to be able to respond quickly to changes in events. I think it's a very big institution. We appreciate the ICC's institutional hierarchy, but it seems too unwieldy at times, and it allows sort of a delay in being able to respond. So, Tripoli was liberated on the 22nd of August. We're now the 22nd of September, actually, so it's exactly a month. And the question we're asked at least half a dozen times every day is, where's the ICC? And this is a practical question. It's not just a moral support question. Every day that there's a delay in people being on the ground collecting this evidence, it's being trampled on by press, it's being taken as memorabilia by opposition or just individuals, and you're dealing with mass graves, etc. It's very difficult not to be collecting that evidence immediately. The fourth area is the way that the ICC works with its partners, perhaps, and I think that's a personal gripe. But I think there's a sense that there is the partnership, for various reasons, the ICC doesn't reveal its partners on the ground collecting evidence for security, for protection, etc. But I think there's a risk there that actually it undermines the work of a lot of the good partners that are doing work on the ground if they are unable to reveal what they're collecting evidence for, or if they're unable to communicate directly between the parties on the ground and the ICC. And so I think there needs to be more of an ownership of those relationships by the court, and its ability to make at least public some of those efforts. The fifth is the one I alluded to at the very start, which is the point of solidarity. I think for a lot of victims, and I include myself in that category, you look to the court on a symbolic level as a symbol of hope, as a symbol that things are going to change, as a symbol of a weight behind you. And I think that's what Resolution 1970 was for a lot of Libyans. It was the international community standing up to Gaddafi and saying enough. And I think it's the whole justice needs to be seen to be done as well. And I think we as lawyers know that all of the magic is happening behind the scenes, and there's a lot of work, but there needs to be a very active communication and of keeping people updated of what the court is doing, so that people feel that justice is being done, and that their case isn't just a political statement at the start of an event. The final one is the security and risk aversion angle, which is what's often quoted by the ICC in terms of not using more witnesses or not including more witnesses in the process. That their aim is to protect witnesses. They don't want to put them in harm by using their statements. And I think there's, at least from my reading, and you can correct me wrong, but it seems like the court aims to avoid risk rather than just mitigate it. And I think for me the definition actually needs to be thought about is whether you're interviewing a person or interviewing a witness, they're endangered because of that act, or they're endangered, full stop. And I think if it's the latter, then a lot of them would be willing to speak. And I think that's one of the biggest hurdles we found. There are a lot of people who are in danger by virtue of the work they're doing anyway in Libya, or by virtue of them just being on the streets in Libya and on TV, appearing on the streets, and would have happily, if you liked, utilized that exposure to a good cause of then giving a statement. And then there is always a sort of a reluctance by the court to put those people in any more danger. And I think it's a lot of negatives, but I think actually the fix is for most of these is pretty simple. I think it's three things that keep coming over and over again, and it's educating people as to what the process is. When you take the mandate, or when you accept the referral from the Security Council, there should be an element and a duty for the ICC to actually educate the people and keep them and keep an understanding of how the court works at a common level, not just at a legal sort of hierarchy level. And the second point is a tangent of that, which is actually using the media properly. And it's not just to make grand prosecutor comments that often don't help the case, but also to actually just keep people informed of the process, and I know that works, because we've seen it work in the Arab Spring generally, but a Twitter feed of what's happening would be helpful. And finally, technology, which is the thing that takes you from the Twitter feed to technology, but even the ability to take more witnesses on board actually could be quite fixed with just a database that allows them in, and then you could spot trends, if not individual witnesses. I think that's it.
Thank you. Now we move to a tribunal of much more specialised jurisdiction, the Special Tribunal for Lebanon, and Herman von Hebel, the Registrar. Thank you.
Thank you very much. It's a great pleasure for me to be here tonight as well. And let me first start off by saying that we recently changed our website, and please do have a look at it, because I think it is an important tool in terms of communication. But as you said, Elizabeth, I think the Lebanon Tribunal is quite a different beast compared to the other tribunals that are represented here tonight. And having served in two other tribunals, at the ICTY and at the Special Court for Sierra Leone, it's actually quite interesting to make a comparison between the various tribunals. But the Lebanon Tribunal is, of course, having an extremely limited mandate. We're not talking about the large-scale war crimes or crimes against humanity or even genocidal acts in countries. We're talking about a very limited number of cases over which we may have jurisdiction. At the moment, we're only looking at one particular case, the Hariri assassination in February 2005, but with that also at a number of connected cases. So the jurisdiction is very limited. However, the impact on the country itself, if we were to be successful, will be tremendous in itself, because it does have an impact on the cycle of violence that has been going on in Lebanon for many decades. The number of political assassinations that have taken place over the last 50, 60 years have really been tremendous, and there's no party, no politician, no opinion leader who has not at times or often constantly been in fear of his or her own life because of the cycle of violence and because of the political climate in which they operate. So in that respect, of course, the work of the tribunal can have a huge impact on the country itself. To go a bit into some legal issues and also triggered off by some of the comments that we've heard before, also in the tribunal there is a discussion, that has been discussion about the role of the common law and the civil law system, and I think our statutes and our rules of procedure actually do have a tendency of going, at least in parts, a bit more into the civil law direction. We have a very strong role for the pretrial judge that leads at the moment the work at the tribunal, to whom the first indictment has been submitted, who has carefully looked in a much more thorough way than I was used to at the ICTY at the whole process of confirmation of the indictment, and is at the moment still leading the whole pretrial preparations. Another element that is different from other tribunals is the separate fourth organ of the organization, the Defense Office, which has its own entire office and will provide support to defense teams. Just for the proper understanding, Defense Office itself will not appear on behalf of any accused, but they will provide support to the defense teams that will be appointed to the accused if they were to come to the tribunal. Another element which we have in common with the ICC, and we're taking also lessons learned from the ICC, is the role of victim participation. I think that is an extremely important role, even though, of course, the number of victims compared to other situations that other tribunals are dealing with may be limited. Still, if we only look at the Hariri assassination itself, the attack on February 2005, we are talking about over 20 people who got killed. So that means a lot of people, a lot of families who have lost a family member. We're talking about over 300 people who got injured. And of course, all those people can consider themselves as victims as well. We think it is an extremely important element to make sure that victims do have a voice in the courtroom. And we have now the first order recently from the pretrial judge that any victim in relation to this attack of which we have a first indictment, will have to declare themselves to participate in those proceedings before the end of October. And we have actually people in the field in Lebanon who are actively being in contact and are trying to get in contact with victims in order to at least give them the opportunity of taking a well-informed decision whether or not to participate. A very interesting different aspect, and probably a very important aspect of the tribunal, is also the fact that we do allow for trials in absentia, which is an element which is completely different from all the other tribunals. Of course, has also led to an enormous amount of academic and political debate as to whether or not you should allow for trials in absentia and what the purpose of trials in absentia are. I think we may, and I will come to that a bit later in more detail, I think it is an element that we may have to use in the foreseeable future, and we will get in the next few months, we'll probably get more into that discussion. The legal basis of the tribunal is a very peculiar one, because on the one hand, although it was meant to be created as a tribunal at the request of Lebanon and after negotiations between Lebanon and the United Nations, that agreement never came to full fruition, but the Security Council took over. So in itself, our legal basis is to a certain extent comparable with that of the ICTY and the ICTR, in that it is created under Chapter 7, but it is only binding on Lebanon itself and not on other countries. It is to a certain extent binding on the Netherlands as being the host state for the tribunal where we're based, but it's primarily binding for Lebanon. Finally, and something that I'm suffering for on a daily basis, it is based on voluntary contributions from countries for at least half of its funding. The other 49%, to be exact, has to come from Lebanon, but the other 51% has to come from the tribunal, from the international donor community. And certainly these days, with financial crisis probably throughout the entire world, funding for a tribunal, which also is, we just recently submitted a new budget for next year, is going to be a tremendous effort in order to see whether the funds can come in and can come in time. I was actually quite surprised when I read the invitation and I saw that I was supposed to talk about the first indictments, plural. Unfortunately, or fortunately, that's a very optimistic view. Unfortunately, we haven't reached that stage yet. We have only one indictment so far. Indictment was submitted by the prosecutor earlier this year in January and then subsequently amended a few times, so that we really have a proper first indictment as of May of this year, which led to the confirmation in late June by the pre-trial judge. That indictment has then been sent to the Lebanese authorities. As I said, under Chapter 7 of the UN Charter, Lebanon is obliged to cooperate with the tribunal and is obliged to search for and arrest, detain and transfer the accused if they were to be found. It was first a 30-day period within which the Prosecutor General of the Supreme Court of Lebanon was to report to the tribunal about all efforts that have been taken. A lot of efforts have been taken, but unfortunately results, or the results that we are all longing for, have not been achieved, in the sense that up till today, none of the 4 accused persons that are mentioned in the indictment have yet been arrested. This week, a second report has come in from the Prosecutor General, and as it is quite clear, the obligation for searching for and arresting the accused persons is an obligation that will continue to be applicable to Lebanon. We have seen the experience in other tribunals. Charles Taylor took a number of years to be arrested. We've seen Mladic, Hadžić, and many others at the ICTY that have only recently been arrested. Even up till today, a number of accused under the ICTR have not yet been arrested. For us, we are at the very early stages. We will have to move on in our preparations for trial, but even if we were to decide that we are going for a trial in absentia, the obligation to search for and arrest the accused persons continues to be applicable and binding on Lebanon. I think the moment for a decision on trials in absentia will probably be taken in the course of next month, towards the end of October. The Lebanese authorities, as I indicated, continue to do a lot of efforts in order to seek where the accused may be and whether they can be arrested. But we have to be realistic as well, and seriously take into consideration that it may not be possible within the very foreseeable future to have those 4 persons being arrested. It is then for the trial chamber of the tribunal to take a decision on whether Lebanon has taken all reasonable measures. As I said, there are a number of reports from the Prosecutor General on which it will primarily be based. And if we were to decide for a trial in absentia, then really the pre-trial preparations will get started. And then we're talking about, first and foremost, of course, the disclosure by the prosecutor of all its supporting material to the accused persons, and in their absence, to the defense teams that will be put together by the defense office. Also, when there are no accused, those defense teams will be established in order to serve the interests of a defense. And of course, these defense teams will have to properly prepare for a trial. Under our rules, they may require a minimum of 4 months, but of course you can imagine that if you have more than 20,000 pages of material, and there may be more to come, then it takes quite a bit of time to really properly prepare. After all, also the prosecutor, of course, has been taking a substantial time, and before the prosecutor's office, the investigations commission, to really investigate these crimes. All in all, I think we are looking for a trial that may get started as of mid next year. Unfortunately, the experience in all the tribunals is that making calculations about judicial activities is certainly not rocket science, and normally there's a tendency that things take more time than are being expected. However, within the tribunal, also knowing, of course, that we have a financial basis that is not rock solid either, we are, of course, under the obligation to make sure that we speed up as much as possible, work as efficiently as possible, and show to our donor community that we're worth the money spending on. And as Howard already indicated, international justice is a very expensive way of doing justice. It's a necessary, but it is an expensive way. As I indicated, the Riri case is not the only case they are dealing with. Recently, there has been a decision by the pre-trial judge to request the Lebanese authorities to refer 3 other cases to the tribunal. The dossiers has been received only a few days ago, and in those 3 cases, the prosecutor will continue to further investigate and see whether there's sufficient basis for the production of an indictment, which will then again be submitted to the pre-trial judge for confirmation. Lastly, in order to conclude, and also following up on Elham's comments, with all the tribunals, I think issues of expectations or management of expectations is an incredibly important thing. In Lebanon, the political situation is an extremely challenging one. There are a number of political parties and groups in society that provide very strong support to the tribunal, but there are equally a huge number of groups that are also very critical of the tribunal. In such a situation, making sure that you are very transparent about the work of the tribunal, hence the website, but there's need for more than a website. Hence the need for outreach, hence the need for a very proactive press office, hence the need for communication with different organizations in Lebanese society is extremely important. Here again, also in that respect, we have only gotten started a few months ago or last year with these kind of activities, but it is certainly something that needs and to be monitored constantly and to be intensified constantly. Because by the end of the day, it is only for, indeed, the victims and the population that the work is being done. Thank you very much.
I'm Anthony Dworkin with the European Council on Foreign Relations. My question is for Elham Saadi. Thanks for your very interesting comments. I was wondering whether there's been, you're aware of any shift in terms of support for transferring cases to the ICC as opposed to trying them within Libya itself, and how that's playing out. Thank you.
Thank you. Let's have another question just because of the time. There's one here. Thank you.
Thank you for the panel. That was very interesting. Bari Alamuddin, Al Hayat newspaper. My question, of course, is about Lebanon, and I wonder if you can tell us: is the court at all thinking of taking Lebanon under, of course, Chapter 7, since we all know where the accused are, Hezbollah land, basically? Is this an option?
Two very interesting and specific questions. Let's deal with them. Elham.
Yeah, I'm glad you asked that question. It's almost like I planted it because it was on the part that I didn't get to. Since the NTC has taken over as the interim government, there's been a lot of talk of domestic justice, and obviously that's all our goals, is to be able to be in a situation where it's domestic justice. There's two questions that always come up with regard to the ICC referral versus the local one. One is what happens to pre-15th of February crimes. Does that mean we press delete on everything if he goes and gets tried there? The second question is the death penalty, which is a big one. And I think with relation to the first half, we always emphasize that actually the complementarity allows for a trial in Libya for pre-15th of February. But the corollary of that is if you end up with a trial pre-15th of February that ends up with a death penalty, and in theory your defendants are in The Hague, you're going to have non-refoulement issues of bringing them back to face that trial. And the second point with the death penalty is one that will always be there if you're dealing with an international situation. And I think that's exactly what we're trying to avoid as an organization, is to have a situation where it is a predetermined sentence and then the trial is just a facade a la Saddam Hussein. And so what our response is as an organization is, well, actually that's not relevant. Sentencing comes at a later stage. Let's focus on the trial. The sentence should be determined by what happens at trial and not the other way around. And so we're trying to push for that motive by the NTC. But the NTC has the first question. Is a very big problem for them, is what happens pre-15th February.
Elham, I've completely forgotten. Does Resolution 1970 date back only to...
Only the 15th of February.
Okay, thank you. Thank you. And your question?
Yeah.
Chapter 7.
Yeah, Chapter 7. Of course, the statute itself was already adopted by the Security Council under Chapter 7, and that means that Lebanon is already now under an obligation to cooperate with the tribunal. The question, I think, to a certain extent translated, what can you do in order to force Lebanon to do more than what they do now? I think on the Lebanese law, but of course it's not for me, it's for the trial chamber, as I explained in October, to really pass on a judgment on that. I do see that the Lebanese authorities are doing a lot, but at the same time also, there are limitations to what they actually can, of course, achieve in Lebanon. The question is, how can you put pressure on Lebanon? Of course, under our statute, if there were to be perceived as a lack of cooperation from the Lebanese authorities, the President may report it to the Security Council. But what does that do by the end of the day? I think under the ISTY, there have been many reports by the presidents of the ISTY to the Security Council, and that in itself doesn't change that much. Obviously, by the end of the day, and we've seen it also with cases like Maric and Hachis recently, it is the pressure on the country in totality, on the governments, to really deliver in the end, and that is in terms of economic pressure and all these kind of things. I think what we see at the moment, for example, when we talk about the question about the funding of the tribunal, that there is an enormous pressure on the Lebanese government to bring the required resources to the tribunal as quickly as possible. I think there's no day that either Prime Minister Mikati or the President or other officials are being reminded of that obligation. The pressure is on, we see that. However, what can the government do if there are within Lebanon also areas where it's very difficult for them to operate? The Security Council can't can't really go beyond that. So the pressure is on, but we have to see how that will work out.
And Lebanon is president of the Security Council
at
as
the
well.
moment, yes. Yeah.
An interesting one.
Yeah.
Right, another question? Yes. Okay. Right. Thank you.
Well, I wasn't going to ask a question. But since,
sorry, introduce yourself.
Sorry, I'm Martha Jean Baker from the Women's International League for Peace and Freedom. I hadn't really planned to ask a question, but since nobody else raised their hand at the moment, I think a number of you alluded to the fact, or very specifically said that there's a lot of misunderstanding or lack of understanding of what the ICC is and can do. And I think that that's a very important thing. I mean, not only for lawyers, but also for the public. I mean, for example, in the past couple of weeks, I have received a number of emails, and I've read a number of things in the newspaper saying, well, of course, after this week, when Palestine gets its recognition in the UN, all these things can go to the ICC, but it isn't quite that simple. And I think we need to, I don't know, it's more of a comment than a question, but I think we need to figure out how we can get people understanding what the ICC can do and can't do, and what further steps might need to be taken before anything involving that region could come before the ICC.
Thank you very much, and that's a message that's been affirmed from the panel. Any last, yes, back there.
Hello, Oliver Trotman, member. I suppose this applies maybe more to Judge Morrison than anyone else, but you commented how judges aren't supposed to make political comments. But to an extent, do you not feel that what you do is being politicised by those indicted by the tribunal? In particular, the AU has issued resolutions urging its members not to honour their international obligations. So is there anything in particular that gives you hope that although these countries are technically bound, the reality is it's worthless at the moment?
Thank you.
Yeah. The problem is that what judges need to be concentrating on is making sure that the trials are as unequivocally and as transparently fair as possible. To that extent, you try your best to separate the law, the jurisprudence, the evidence from any political consideration. The idea that you can separate international justice from politics is, however, completely fatuous. You can't. It's riddled with it from the very beginnings. When you looked at the negotiations of the Rome Statute, when you heard the arguments that were put forward why people should and shouldn't join, it was intensely political. It wasn't an exercise in jurisprudence. I think the best example I can give as far as the ICTY is concerned is to look at the special courts which have been established in Sarajevo, in Zagreb, and in Belgrade. I visited all of them, and I'm in the chamber in the ICTY that has to determine what evidence comes from ITCY records that goes to those courts when they are trying the cases, which means an awful lot of reading of transcripts to make sure that protected witnesses don't get implicated, etc., etc. But the point is that it's working very well, and those courts are doing a fantastic job, there's no two ways about it, and particularly in Belgrade, they're doing a fantastic job against political pressure in some quarters, and under threat. I mean, the judges there are probably under greater security threat than certainly I am, or judges in many of the other tribunals. So to say that there isn't a political aspect to it, I say, is fatuous and unrealistic. The judges have to separate themselves best they can. The important thing to remember is that in any country which has voted for the ICC or voted to do something relating to international law, if it's a democracy, then it's probably only a proportion of the society that's voted for it in any way. And there is always going to be the proportion of that society that didn't vote for it, who will one day come into the ascendancy again, as they do in a democracy. You have a change of political party, you have a change of political attitude. You saw in Kenya, after Kenya, a great supporter of the ICC, but when you read some of the comments in the Kenyan press after the indictments or purported investigations, you wonder if Kenya was a supporter of the ICC. So I'm afraid it's the real politic.
Thank you. Will you close first?
Yes, just following on that question, I think does lead into thanks for our participants, because of course it's impossible for judges to get into the ring, but it's very difficult for them not, because they believe in international justice. And the first, Kasisi was the first president of the ICTY, and he was so frustrated by the failure of politicians and diplomats. And diplomats are the enemy. They don't really believe. I say this at Chatham House, and I feel it. They don't believe in criminal justice. They believe in diplomatic expediency. They want to organize deals so that the tyrants leave the bloody stage with the amnesty in their back pockets and their Swiss bank account intact. That's what they want. But Kasisi got so furious with having no indictments that he demanded that Serbia should be expelled from the Olympic Games. And it did throw a question over impartiality. So judges have to, believe in it and explain it, and we have in Howard and in Herman, as the registrar, we have to thank them, and of course from Rod, for coming out of their shells and going as far as they can, properly go, to actually elucidate and enlighten and to show what the real problems are, because we have created these expectations. We've created them, as Elham said, and we have to hope that our politicians and diplomats will live up to them. Elham, I have a terrible confession to make. A few months ago, an Australian solicitor was hired by Gaddafi. He was taken over from his practice to Tripoli. And I got a call from him asking would I act for the colonel. And I said, well, I have described him as the worst man left in the world, but I'd be delighted to act for him on the taxi rank principle, and also because I thought that there would be a certain piquancy in going into the ICC on his behalf. And so for some months I was consulting with the group of Gaddafi advisors. We tried to set up a high court action where we bring an action here to try and stop, for an injunction to stop Britain being part of a NATO bombing plan. We found a solicitor who would act, but only with money. And there was a slight difficulty with the UN regulations that stopped anyone using Libyan funds, so he didn't get that off the ground. But going into the ICC was quite interesting, because I explained to the Libyans that they would have to accept the ICC, but by gosh, we could make a terrific case against these prosecutors who are making these ludicrous allegations about Gaddafi, supplying his troops with Viagra so that they could go about mass rape. We could certainly shoot down that one. But of course, this looked very promising for a couple of weeks, but then the penny dropped for the Libyans, and that they realized that sending us into the ICC would mean that they would be accepting up to a point ICC jurisdiction. And once that penny dropped, they decided that they could not do this. And indeed, the solicitor who was instructing me decided that the Gaddafi people were so obnoxious that he wouldn't act anymore, and that was the end of that. But it is important, and this brings back to Howard's point, it is important that we are equal-handed. It is important that the ICC prosecution not be allowed to make the running, because it is, after all, an adversary system, and it has to be fair, and that is why the comments about having a defence office. We started the defence office in Sierra Leone, and I think it's a very important part of international law, because it is, and the other point, of course, which must never be forgotten, is that even-handedness means you've got to look at the allegations against the rebels in Libya. It is difficult, and of course the allegation that international justice is victor's justice was one that's been made against Nuremberg and Tokyo. And it is hard. I mean, in Sierra Leone, the prosecution arrested King Norman, who was in effect, the Home Secretary of the new government. He had fought for the democratic government and had, against the RUF and the rebel groups who were the main violators, but he had used child soldiers to do it. And it was extraordinary. He was arrested as he was going into a cabinet meeting, and we took him to our prison, and all the guards would salute him. And it's not a good situation to have your prisoners being saluted by your guards, but that it was important, nonetheless, to show that it was equal-handed. So that's another task among many that we're loading upon the ICC, and we must wish them well. And thank you all for coming.